session.
Good morning and welcome to the Tennessee Court of Appeals. We appreciate each of you and your clients agreeing to participate in this video Zoom oral argument. It's again, not the best process, but the process that we think will be best utilized under these circumstances. Both of you are experienced practitioners and understand the rules and procedures of the court, and we'll be operating under those same rules as if we were in the courtroom today. That means each side gets 15 minutes to make its oral argument, and if you're the appellant and have reserved time previously with Mr. Hibner, you'll receive that rebuttal time. Before we start today, I want to introduce our panel. It's Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
You may call the case then.
In re James W. et al.
All right, we will hear from the appellant.
May it please the court. My name is Linda Mulligan. I represent the appellant, Jennifer Loy. This is a DCS termination case. There were 5 grounds for termination that were found by the lower court. Termination is a remedy of last resort. Appellants would argue that the better option in this case, under the particular facts of this case, would have been permanent guardianship for Tyler Walter and a return of custody of the youngest child to the mother. The child's name is Reagan. This would have been better because it's undisputed that there is a very meaningful and very strong bond between the mother and her 4 children. 2 of the children have aged out. Greg Walters aged out shortly after the termination trial was held. Both boys testified, Tyler and Greg testified at trial that they did not want to be adopted. The appellant, it is also undisputed that the foster father for the boys, Marvis Strickland, is a wonderful role model. He has done a really great job with the boys. An appellant would like her son, Tyler, to remain with him, but under a permanent guardianship, allowing her some visitation with him. Tyler and Greg both testified that they wanted a continuing relationship with their mother. And also, Mr. Marvis Strickland, the foster father, did testify that he had no objections to the mother having continuing contact with the boys. All of her contact during the time that he was the foster father was always appropriate, and the boys always looked forward to having contact with their mother.
Ms. Mulligan.
The mother at this—
Ms. Mulligan.
Yes, Your Honor.
You're going into an argument here about permanent guardianship, but was that was that what this case was about? Was that even an option in this case? Was that pled in this case? Was this a case to establish a guardianship of any sort, or was this a termination proceeding?
This was a termination proceeding. However, at the TPR trial, I did request the court to consider permanent guardianship as another option under the facts of this particular case, Your Honor. DCS chose to terminate the mother's rights in lieu of a permanent guardianship, which is usually not favored by DCS. And at the time of the TPR trial, Your Honor, the mother had been in rehabilitation at a very intensive residential treatment in Morristown, Abundant Hope Ministries, and she had successfully completed the first 3 phases of that very intensive program. And she was actually in the 4th phase. 2 members of Abundant Hope testified on her behalf. Corey Letterman, the executive director of Abundant Hope, and also her counselor there, Audrey Serber. They both testified that she had been totally compliant and that she will have completed all of the requirements of the Roane County Recovery Court once she had completed their program and remained in Morristown. Roane County Recovery Court did submit a letter saying—
Counsel, what does that mean? She's in this treatment program. How long will this treatment program last, and what are the parameters of the treatment program once it's completed?
Okay, Abundant Hope explained that during the trial. Corey Letterman said that it's a very intensive program. The first 3 phases of the program require that the resident address her sobriety and gain the tools to overcome the vicious cycle of drug addiction. In the 4th phase, which was the phase that the mother was at that point in time, she was allowed to go off campus, apply for housing, and also seek employment. The first 3 phases did not permit the mother to do this because she needed to concentrate on her recovery. But at the time of trial, Corey Letterman and her counselor testified that she did have the tools, she had been compliant. They also testified that they had created with her a safety net, and she had a plan as to what she needed to do. At the time of trial, she had been applying for housing, and she had also been seeking employment. Abundant Life was going to provide a very good support system for her to prevent her from relapse. The mother had indicated that she will remain in Morristown to continue receiving wraparound services and support from Abundant Hope. Greg Walters, her oldest son, testified that he had noticed a great change in the mother's demeanor, that as far as he was concerned, Abundant Life had made a very important change in his mother. And even the Mr. Letterman and Ms. Serber were convinced that she had made a lasting adjustment in her circumstances.
Did she testify?
And also she was going to resolve her.
Counsel, did
Yes,
she
Your Honor.
testify that she was able to take custody of these children now?
Your Honor, she was seeking a housing, and according to Mr. Letterman, she was on a waiting list. It would take approximately 1 month to 3 months. It could be quicker if they could have gotten a letter from DCS that she could get custody back. That was at the time of trial. She was on a waiting list. And they said that
that's the only issue that she believed that she had that would prevent her from taking custody of these children at this time.
Your Honor, if I may respond in the sense that the main focus of her permanency plan with DCS was to address her sobriety. That was the main focus, the primary focus. Yes, she was supposed to get housing and employment, but the whole reason for the history with DCS was substance abuse. And at this point in time, this was the first program. The mother had been in a previous rehab program for 28 days. It hadn't worked for her. Also, I want to call attention to the fact that in the case of Gabriella D,
Ms. Mulligan.
Yes, Your Honor.
My question
Yes.
is, was the housing the only thing that was prohibiting her from being able to take custody of these children at this time?
Yes, Your Honor. I would say that was the only remaining thing, and also, getting
Okay.
gainful
Hold on
employment so
just a
that she
second.
could support herself.
Right. So
Okay.
what was the testimony about anything that was an impediment to her being able to say, or did she say, I can take custody of these children at this time? I'm ready, willing, and able to do it.
Actually, she was ready and willing. She just needed to find housing. Mr. Letterman testified that she had already saved up a security deposit for the possible rent. She had also gotten her driver's license. She had car insurance, and her family was going to help her purchase a vehicle, but she needed to complete the 4th phase of this particular program. And at this particular phase, and she was going to graduate within 2 months of the TPR trial. And at that point, they were going to provide her with wraparound services to prevent her from relapsing. Her counselor felt that she was ready to take custody, as well as Mr. Letterman. They had glowing testimony regarding my client's progress in this particular program. I think my client's downfall was her toxic relationship with her husband, Scotty Loy. She always did really well while he was incarcerated. I mean, she did struggle to pay her bills. She has a limited education and not very many skills. And she relied on Mr. Scotty Loy when he was released from jail for financial assistance. But as a single parent, even though she was struggling, she was always compliant. She attended almost every child and family team meeting. She was compliant with Roane County Recovery Court, with West Care before she went into Abundant Hope. She did go AWOL, and that was shortly after Scotty Loy was released from jail. But as soon as she was arrested and she was admitted to Abundant Hope, she turned her life around. And just like the case of In re Gabriella D, a Tennessee Supreme Court decision in 2017, in that particular case, the children were removed from her because one of the children, an infant, was severely malnourished. Most of the removals concerning my client were based on substance abuse. The last one was because she was incarcerated. And in the case of Gabriella, the mother also essentially had non-existent parenting skills when DCS first became involved with her, just like Jennifer. And also the focus,
Ms. Mulligan,
the mother's focus in Gabriella.
Ms. Mulligan,
Yes, Your Honor.
hadn't DCS
Yes.
been involved with your client for a number of years?
Your Honor, DCS was involved in 2012 and in 2016, and then the last time was in June of 2019. My client had 4 children back in 2012. They were
Thank you.
difficult children to handle, and thank you, Your Honor.
All right, you've answered her question, Ms. Mulligan. You still have your rebuttal, and we will hear from the appellee now.
May it please the court. Good morning, Your Honors. Amber Seymour from the Attorney General's office on behalf of the Department of Children's Services. Your Honors, this case is about 2 children who deserve permanency. They have spent the majority of their childhoods in DCS custody, and they deserve the opportunity to finally have a permanent home that's free from crime and substance abuse. The termination of mother's parental rights should be affirmed for 2 reasons. First, there are 5 alternative grounds for termination that were established at trial. And second, terminating mother's rights is in the best interest of these children. As a bit of background, this is the 3rd custodial episode for these children. They were removed from mother for the first time in 2012 and returned in 2013. They were removed again in 2016 and returned incrementally in 2018. And then less than 6 months after all 4 children had been returned to mother after the 2nd custodial episode, mother relapsed again, and she ended up violating her probation and being incarcerated, which led to the current custodial episode when the children were removed in June of 2019. And mother was incarcerated at the time of that removal. They have been in continuous foster care since the June 2019 removal. And over the many years since 2012, mother has received continuous DCS services. But despite these services, she still has not shown that she can provide a safe and permanent home for these children. As already mentioned, there were originally 4 children part of these proceedings, but 2 of them have now turned 18. So the only parental rights at stake now in this appeal are that to Tyler and Reagan, who are both still under the age of 18. I do want to briefly address the argument about permanent guardianship. To answer Judge McGee's question, there was no petition filed by Mr. Strickland seeking permanent guardianship. Definitely nothing asking for permanent guardianship under Title 37, which is what mother is requesting in her brief. This appeal is only of the department's petition to terminate mother's rights and seek guardianship for DCS under Title 36. And Title 36 explicitly does not provide authority to grant a permanent guardianship under Title 37. Turning to the first ground for termination, mother abandoned the children by failing to provide a suitable home for them. The children were removed into DCS custody pursuant to a court order. There was a petition alleging dependency and neglect that was filed in the course of the proceedings. And the juvenile court at the time of removal did make a finding that DCS made reasonable efforts to prevent the removal. The removal actually happened after both mother and the oldest boy, who is now over 18, tested positive for THC. They worked with mother and tried to help, but then she ended up getting incarcerated, and that's when the removal happened. In the 4 months that followed the removal, which would have been June through October of 2019, DCS continued to make reasonable efforts and tried to assist mother to work towards reunification. DCS requested a hair follicle screen, provided therapeutic visitation, developed a permanency plan, arranged child and family team meetings. They worked with West Care, which was the court-ordered treatment program that Mother was initially supposed to participate in. DCS looked for housing for Mother and helped arrange transportation to court hearings. But Mother's efforts during that 4-month period were not reciprocal. She only visited the children on 2 occasions. She made no efforts to move into a home, even though West Care arranged an apartment for her. She never moved into it. She missed a West Care class that she never made up. She missed a probation appointment, a therapy appointment. She was incarcerated for after-trial minimus. She failed a drug screen and admitted to using methamphetamine in August of 2019. And when she was told she would need additional treatment after that failed screen, she went on the run until she was later arrested at the end of October, early November of that year. The second ground is that Mother abandoned the child by behaving in a way that exhibits a wanton disregard for their welfare. To trigger that ground, Mother was incarcerated within the statutory 4-month period. The 4-month period was from September 9th of 2019 through January 9th of 2020, and she was incarcerated for all of November through December 9th when she was released to go to Abundant Hope. Prior to that November incarceration, however, her behavior did exhibit a wanton disregard. She violated her probation, which is what led to the incarceration at the time of removal. She only visited the children twice. She did not move into that apartment West Care arranged. She missed the drug class, the therapy appointment, the probation appointment. She was incarcerated 2 other times. She failed a drug screen and she went on the run. And so none of these behaviors show a regard for the children's welfare. The third ground is that Mother was in substantial noncompliance with the responsibilities of the permanency plan. When the termination petition was filed in January of 2019, the operative permanency plan was the January 2020 was when the petition was filed. The operative plan at that time was the July 2019 plan still. Mother's responsibilities on that plan, generally speaking, included addressing her substance abuse, resolving her legal charges, visiting with the children, maintaining appropriate housing, and submitting a transportation plan. At the time that the petition was filed, Mother had not completed any of these tasks. She had just begun to address her substance abuse. She had been at Abundant Hope, which was the court-ordered program at that time, for about a month. But before that, again, she failed to comply with the West Care, which was the court-ordered program. She went on the run. She was incarcerated at 3 different points. She failed a drug screen. She did not attend appointments. She had not completed the hair follicle screen, and she had not completed parenting classes. And even looking at her post-petition behavior, and the second permanency plan that was developed after the petition had the same requirements as the first. But even looking at her post-petition behavior, the compliance that Mother alleges is still prospective. Though she should absolutely be commended for her time at Abundant Hope, she still did not have housing. She did not have employment. She had not graduated yet from Abundant Hope. So she hadn't graduated from drug court and still had that looming over her. And she was months away from achieving any of that. The fourth ground is that Mother failed to remedy persistent conditions that prevented reunification. With this ground, the children were removed by a court order in June of 2019. And the petition and the trial to terminate her rights were more than 6 months after the removal. And there was a petition alleging dependency and neglect filed in the proceedings. Conditions that prevented reunification still persisted. Again, absolutely, she should be commended for the progress she had made at Abundant Hope, but that did not change the fact that she did not have housing or employment. She hadn't completed that program. There wasn't a guarantee that she would complete that program or that she would graduate from drug court, and she waited until the day of trial before she submitted a transportation plan to DCS. And then Mother herself testified at trial that even when she had housing, she would only be able to care for Reagan and not for Reagan and Tyler both. There was little likelihood that the conditions would be remedied soon. Mother has had years and years of DCS services, and she was still, even at trial, months away from graduating from Abundant Hope and drug court. And there were still lingering concerns about her ability to maintain sobriety or maintain housing employment following her completion of the program based on her history and the failed treatment that she'd had in the past. And there were certainly still concerns about Mother's relationship to her husband. They were still married at trial, though she testified she would divorce him. That had not happened yet. And a DCS worker testified that mother had said she would leave Mr. Loy many times over the years, and she had never done so. And the final element of that ground, continuing the child's relationship with mother would diminish the children's chances of early integration to a permanent home. Again, the children spent the majority of their lives since 2012 in state custody, and they've thrived in foster care. They've matured, they've shown improvement. Reagan's behaviors had significantly improved since the prior custodial episode. Both children were receiving therapy and medication management. And over the years, the trial court found the only stability the children had were when they were in foster care. And so they deserve to finally have true permanency outside of foster care. And then the final ground issue is that mother failed to manifest an ability and willingness to assume custody of the children. Again, for many of the same reasons the other grounds have been met. She failed to comply with West Care when that was court ordered. She failed a drug screen. She didn't move into the apartment that was made available to her. She missed appointments. She went on the run. She was incarcerated at 3 different times. And even at trial, she lacked housing and employment. And there was still no guarantee that she would complete the program Abundant Hope and graduate from drug court. And there is still a risk of substantial harm to these children. Again, mother was still 4 months away from graduating the program. There was no guarantee that that would happen or that she would maintain sobriety, or if she were to achieve housing and employment, that she would maintain that either. And these children have been yanked from their homes at 3 times already, returning them to a mother who we really don't know if she's going to have long-term sobriety, which is what the children need to have in their lives. We don't want to risk them being pulled from her just 6 months down the road yet again, which has been the history since 2012. So because at least one ground has been established by the evidence, this court must also determine that termination is in the children's best interest. And as this court is aware, there are 9 non-exhaustive factors to consider in this analysis. And I'm going to highlight just a few that are most relevant from the evidence in this case. The first 2 factors certainly weigh in favor of terminating mother's parental rights. Mother's not made a lasting adjustment of circumstances. She's not made changes in her lifestyle, despite many, many years of efforts from DCS. She was still in the court-ordered treatment program. She could not assume custody of the children at that time. She could not assume custody of either children at that time due to lack of housing and lack of employment and still being in this program. But she even admitted that she could not assume custody of both children, even if she were to remedy those impediments. And And so factors 3 and 4, though mother did have regular visitation following the filing of the termination petition, she did not do that before the petition was filed. She only visited the children twice, once in July and once in August of 2019. But she did have a meaningful relationship with the children. Factor 6, the mother did expose the children to drug use and criminal activity in the home prior to the removal. Greg testified about seeing mother strung out on drugs on different occasions. And so the children were aware of that conduct and were exposed to that in the home, which is what led to multiple removals over the years. Factor 7, following the removal, mother was still engaging in criminal activity by using illegal drugs. She had that positive test in August of 2019, admitting to using methamphetamine, and then went on the run when she was told she'd have to have treatment for it. And then finally, factor 5, which is changing the children's physical environment, would have a negative impact on their welfare. The trial court found that the only stability these children have had over the years is when they're in foster care. And they were doing so well in foster care. They were receiving therapy and medication management. Reagan had recently just been moved to a pre-adoptive home, and Tyler was in a pre-adoptive home. His foster dad, Mr. Strickland, testified that he would have loved to adopt Tyler if that's what Tyler wanted, and he could change his mind about it. And Tyler did testify that he was willing to stay with Mr. Strickland if he could not be returned to mother's care. And Mr. Strickland also testified that he would even consider adopting both Tyler and Reagan so that they could be together. He would just ask that he have some time to get to know Reagan so they could start to form a bond before that happens. And so over the many, many years that mother's received services, she's really not made lasting changes or proven that she can maintain changes, even with receiving services that wrap around. And so these children deserve a chance to finally have permanency for the few years of their childhood they have left. So for these reasons, because the trial court properly found grounds to terminate mother's parental rights, and because termination was in the children's best interest, this court should allow the children to finally have that permanency and affirm the judgment of the court that terminates mother's parental rights. Thank you.
Thank you. We will hear from the appellant in rebuttal.
Thank you, Your Honor. First of all, this family is a family unit. The family services worker, Michelle Weisel, testified that this family is a unit. If the mother's rights are terminated, it's very likely that Reagan, the youngest child, will be adopted, and her relationship with her 3 older siblings and her mother will be forever severed. Now, the fact that my client didn't have stable housing and employment at the time of the TPR trial, the fact is that she was able or was going to be able to get housing and employment within a reasonable time. It wasn't like you didn't know when she was going to have it. She was, and Mr. Letterman and Ms. Serber testified that they were assisting her. She was on a waiting list, and within a reasonable time, she would have housing and employment. The mother was compliant previously with DCS. She had regained custody. The children had been transitioned back to her home with the last removal in June of 2019. Mother had demonstrated that she had the appropriate parenting skills, which she had acquired with the assistance of DCS. And Mr. Strickland testified that her parenting skills were fine, and he was willing to continue to allow her contact, but he was prohibited by DCS after the TPR. She was compliant with WestCare and the Roane County Recovery Court after she was arrested and got out. It wasn't until her toxic relationship with her husband, when he was released, that she had a relapse. Yes, she panicked, but once she got into Abundant Hope, she turned her life around. She has made a lasting adjustment in her lifestyle. And this was testified to by both Mr. Letterman and Ms. Serber. In fact, WestCare was not the one that had gotten her an apartment. If you look at the WestCare records, it was the mother had acquired an apartment right before she went AWOL. She had been compliant with their program. And it wasn't until Mr. Lloyd got out that she had this relapse. Now, the mother has had successes. She's had setbacks. She's regrettably backslided, but she has successfully completed, and I disagree with Ms. Seymour. She was on the verge of completing this program. Mr. Letterman and Ms. Serber had absolutely no doubt that she would successfully complete their program. And the recovery court, any legal outstanding issues that my client had would have been resolved once she completed and graduated from Abundant Hope. She has, there's been no recent incidents of drug abuse since she was with Abundant Hope. She has remained clean. She has prioritized her children and put their needs above her own. She is not in an unstable environment. She is in a very nurturing, supportive environment at Abundant Hope. Again, Greg Tyler, her oldest son, said that there was an amazing change, and he credited it to Abundant Hope, and that she would not have a detrimental effect, and she would not create a substantial risk of harm to any of her children. Now, my client would love to have both children, but she recognizes that Mr. Strickland is a great role model, male role model for her son. And she wanted him to remain in, and she was acting in his best interest. She feels very comfortable being able to parent her youngest daughter, Reagan. Again, this is a family unit, a very tight family unit. Both boys said that they would be very saddened if they were not able to see their sister again. My client has indicated to the Abundant Hope staff that she does plan to divorce Scotty because of their toxic relationship, and they don't have any doubts that she will follow through with this. I feel that she has done what she could to better herself. She is in a much better position than she's ever been. Even with DCS's services, it wasn't until she got into Abundant Hope that she actually turned her life around and is willing to leave this toxic relationship that she had with her husband and move on and prioritize her children, and basically has conquered her substance abuse issues. And I think by remaining in Morristown and having wraparound services and a support system, that she can parent Reagan, and she wants to have continued contact with her son, Tyler. And I hope that the court will reverse the termination finding. Thank you.
Right, thank you for your argument. We will take this matter under advisement and try to render an opinion at the earliest possible date. We again appreciate your participation via Zoom, you and your clients both. Want to thank Mr. Hivner and his staff, as well as the AOC technology staff, for the wonderful job they do in making this possible. Mr. Hivner, if you would recess court to the call of the next docket, please.
This honorable court is now adjourned.
Thank you.
Thank you.